Well, welcome everyone, and thank you so much for joining me for this session. I am Lior Samfiru, the employment lawyer, and you've landed on my live stream session. So yes, once a month, once a month, once a week, sometimes twice a week, I log on right here to talk to you about employment law, to talk to you about workplace rights, and most importantly, to answer your questions live. So again, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. They call me the employment lawyer because that's what I do. I help people with workplace rights. I help you understand and enforce those rights that you have on your job, in your workplace, with your boss, in your employment. So this is your opportunity right here and right now to get some answers, to get some clarity, and hopefully to get some peace of mind when it comes to your employment rights. This is a live session. Okay, this is a live back and forth between you and I. So what I want from you is I want your question. I want you to ask me about the issues that you're dealing with your job, with your boss. Maybe you've lost your job. A lot of people have been calling me the last month or so, losing their job. Let's talk about that. Let's talk about if it's legal, if it's not legal, what you're owed. I want to talk to you if you're being mistreated or harassed or bullied. Let's talk about what to do in that situation. Let's talk about what happens if your job has changed, your hours, your pay, your location. If your employer is telling you you have to come work in office and you've been working remotely, what does that mean? Can they do that? Ask me those questions. Ask me any questions about workplace rights. This is about you and your opportunity to get some clarity, to get some answers. So don't be bashful. There's no bad question. There's only answers and solutions and help. I see questions are coming in. I'm going to start answering them just a moment. Before I do, I want to give you some other contact information. If you want to connect with me and my team off live stream, off social media, so easy to do. You see that address on the screen. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information you need is right there. Phone number, email address, fax number if you prefer. It's all right there for you at employmentlawyer.ca. But right now, for the next 30 minutes, I'm Lior Samfiru, of course, the employment lawyer with Samfiru Tumarkin LLP. And the reason I got dressed up and put my tie on is because I want to talk to you and answer your questions live. This is your session, your time, your opportunity to get help. So just like some people have asked questions, ask yours. You ask a question now, you get guaranteed an answer during this session. So please, let's make sure we have that. Again, Lior Samfiru, that's me. Samfiru Tumarkin, my law firm. Let's start answering questions. And as you listen to me, ask your question as well, all right? All right, let's see. First one off the bat is a question from Abby, who's joining us on Reddit. I have been working remotely for a UK-based company and am now being let go. What are my rights in this situation? Should I speak to a lawyer in the UK? That's a great question. I get that asked often. So what laws apply? Very, very simple. The laws that apply to you are the laws of the location where you actually physically work. So if you work from home in Ontario, but the company maybe is based in the US or in the UK, we don't care about those laws. We care about the laws of Ontario because that's where you're physically working, even if you're working from home. So it's not where the company is based. It's not what their company's headquarters are or where their HR office is. None of that matters. What matters is where you're physically located. And that's very good because you're going to have significant rights in Ontario or in Canada generally that you may not have in other countries. So yes, if you're Abby, you're working in Canada, that's the laws of that province that apply to you, and you're being let go. So if you're being let go, you're owed severance. We can't do much about the fact that you were let go. Generally speaking, an employer is able to let you go at any time and pretty much for any reason, as long as they pay proper severance. So for you, it's a question of severance. That's what it is. So ultimately, yes, they can let you go, but severance has to be paid. Now, Abby, you didn't tell me how old you are, the type of job that you have, and the length of your employment. So I can't assess what you're owed. So here's what I'm going to tell you. As soon as you know you're being let go, call me, okay? Let's discuss this. I'll make sure you get what you're owed. There's a very good chance that you're going to be offered less than what you're owed. That's what happens in 90% of cases. So connect with me as soon as you're let go. Employmentlawyer.ca is the way to do that. Again, employmentlawyer.ca. So make sure you use that. Thank you for that question. Great question right off the bat. If you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, answering your questions live. Bunch of questions have come in. I will answer every single one of them, all of them. So stay tuned. Let's go back to the next question. Second question today is from Facebook, and that's from Carmen. My employer has told me that they will be reducing my hourly pay and changing my hours to give more time to less senior staff. After 7 years, are they allowed to just make these changes? What can I do? So no, generally speaking, they're not allowed to make these changes, Carmen. Now, the fact that they're not allowed does not mean that there's a way to physically stop them. We can't send in the police to arrest them if they reduce your hours or your pay. So what does that mean? What can you do? Well, if they change your, reduce your hours, reduce your pay, you may be able to consider that to be a constructive dismissal. What does that mean? That means that because they've reduced your pay and hours, you may be able to say, you've terminated my employment. I am choosing to look at this as a termination of employment. And now, employer, you have to pay me my full severance. And again, 7 years, you could easily be looking at 8, 9, 10 months even of severance. So that's what it says at stake here for you. You can't physically stop them, but that could be a constructive dismissal. And the problem is this: if you don't do that, if you accept the change, you accept the reduction, you're not happy, but you accept it. By doing that, you're now giving them the right to do it again and again. And if they do it a second and a third time, it won't be a constructive dismissal because you let it happen that first time. So your best option may be to say, no, constructive dismissal. So if that's what you want to do, before you do anything, before you say anything to your employer, call me, okay? Let's connect off air. Let's have a proper discussion. You can reach me, of course, through employmentlawyer.ca. You see that right over there, employmentlawyer.ca. But that's a constructive dismissal. It's not something your employer is allowed to do. So keep that in mind. For everyone else, reductions in pay, reduction in hours, demotion, all those can be constructive dismissal. So if that's your situation, we should talk about that right away. Again, I'm Lior Samfiru, the employment lawyer. If you've just joined us here live today, answering your questions on employment law. Bunch of questions have come in. I'm going to continue answering them right now. Please ask yours. You got tons of time, okay? Tons of time to ask your question. All right. Alphanor has our next question. My employer has been forcing us to work through the recent heat wave. It's led to a number of my coworkers suffering heat exhaustion. Are we allowed to refuse to work if the temperatures are unsafe? So the answer is yes. So if an employer is going to have you work in extreme temperatures, it needs to give you have proper precautions to not put you at risk. That may mean having areas that you can go get some shade, having proper water, giving enough breaks so you're not in the sun the whole time. They have to take these precautions to ensure that the work is safe. Just telling people you have to be out in the sun for 8 hours or 10 hours, not proper. That could be breach of occupational health and safety requirements. So yes, you are able to refuse work that's unsafe. What does that mean? What happens in that situation is your employer then has to do something, give you some help and support to ensure that the workplace is safe. If they don't do that, then what they have to do is they have to call an inspector from the Ministry of Labor who's going to decide if the work is safe or not. If that inspector says it's safe, you have to go back to work. If they decide that it's not, they're going to order your employer to make some changes. The key is you cannot be punished for refusing that unsafe work. You cannot be punished for telling your employer this is unsafe, even if the inspector ultimately disagrees with you. And that inspector from the Ministry of Labor says, no, it is safe. You still cannot be punished for doing that, okay? So very important. It's a big issue right now with the warm temperatures that we're having across the country. So yes, I recently did an interview with one of the big papers on this. So you can refuse, and I would say you should refuse work that's unsafe. You don't want to put yourself in a difficult or dangerous situation, end up in the hospital or worse. So definitely keep that in mind. Any problems, you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that great question, and I hope that helps. Any follow-up questions, I'm still here. Fantastic questions, guys, to start. Great questions. I see a bunch more have come in. Please ask yours as well. I want to be busy on this session. I want to be answering tons and tons of questions. I want to be out of breath at the end of it because I've answered so many questions. So please don't be bashful. It's no trouble. There's no such thing as a bad question. There's only answers, solutions, and help. But right now, I'm going to continue answering questions. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you here. Michelle has our next question. Our manager has been forcing staff to work through our lunch break in order to stay on top of our quotas. He then removed that time from our timesheets and we won't get paid for the extra time. Is this legal? Can they expect us to work through the lunch and not pay us? So it's illegal on a couple of respects. First of all, they have to give you a break, okay? They don't get to say, well, we're busy, so you don't take a break. And so that's illegal. But then they're doing something else that's illegal. They're also not paying you for time that they're demanding that you work. So it's illegal in both respects, completely illegal. So if you tell your employer, sorry, employer, I'm not going to work through my break, you cannot be punished for that. It would be called a reprisal. If you demand to get paid for time that you do work, you can't be punished for that. I can help you make sure you get paid. You can also file a complaint with the Ministry of Labor if you don't get paid. It's illegal in both respects. A break is not something your employer gives you because they're nice. They have to. Now, the breaks generally are unpaid. They don't have to pay you for that, but they also can't require you to work. So, Michelle, everything you've just described completely and totally and utterly illegal. If you want me to get your employer to change, trust me, a letter from me is all it's going to take. So you can reach out to me. Otherwise, you can file a complaint with the Ministry of Labor. Very illegal, and I'm sorry you're going through that. So hopefully that's helpful. Michelle, any follow-up questions? Hey, I'm still here. Haven't gone anywhere. You can ask it right now. And everyone else, thank you, by the way. Questions will come in. I'm going to answer them. Your question is going to come as well, I'm sure. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I think the best thing I could do right now is answer the next question. So let's do that. Zelaki, sorry. let's go with Zelasi. Has our next question. I worked 2 years for a company and then I quit because I got a new job. I worked for the new company for a month, but got dismissed because I didn't pass training. Am I entitled to EI? The answer is yes. By the way, you could also be entitled to severance from that company. Yes, I know you've only worked for a month, but you could be entitled to severance, and that severance could even be longer than the length of your employment. That's true, especially if you were recruited from another company, from that previous company, but it would be true even if you didn't, even if you weren't recruited away. So we should probably talk about that, Zelasi. And yes, you do qualify for EI as well. So thank you for that question, and very, very important to keep that in mind. Now, this is a good opportunity to tell you about something else. I told Zelasi that even after a month, she's owed severance. A lot of people are surprised by that because a lot of people are surprised by just how much severance you get, how much severance the law says you should be getting. So how do you find out exactly how much severance is? Because guess what? It's not a week per year. It's not 2 weeks per year. It's a lot more than that. So here's how you can find out quickly in seconds how much severance you are owed. All you do is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address on the screen right now. And when you're there, all you do is you click on the severance calculator. That's it. Couldn't be simpler. On the severance calculator, you answer a few questions, and that's it. You'll find out how much severance you are owed. Maybe it's 2 months severance. Maybe it's 24 months severance. Maybe it's something completely else, completely different. It's right there. It's easy. It's free. I got to tell you, it's free. People think there's a catch to it. I have to pay. I have to give a credit card number. I have to sign up for a subscription. No, it's completely free. It's completely anonymous. No names, phone numbers. And if you want to, and only if you want to, you can contact me directly from that severance calculator. So check out pocketemploymentlawyer.ca. Whether you worked for a month or 25 years or anything else, check it out. You'll be surprised. I guarantee you'll be surprised to learn how much severance you are legally owed. Okay, pocketemploymentlawyer.ca. Click on the severance calculator. All right, let's see. Great question, but right now, you don't have to worry about anything other than asking me a question. Asking me a question about your workplace, right, so that I can answer it. All right, let's continue right now with the questions that have come in. Where have I left up? BC Pinoy. My wife is working in a unionized workplace in BC. She filed a human rights complaint in the BC Human Rights Tribunal and got accepted. Does your firm handle this kind of case in mediation or litigation in the future? Absolutely, we do this all the time. So happy to have her connect with us to do that. All she has to do is go to employmentlawyer.ca, and all the contact information is right there. Next question is from, let's see, Alpha Gaming. Employment contract had a clause where if we were laid off, it's statutory minimums plus 3 days. This was signed 3 years ago. Have there been any updates in common law that may allow for greater severance? So this has nothing to do with common law. What you did there is you signed an employment agreement that tries to say, forget about common law. We don't care. We eliminate common law. We're simply going to pay you what this contract says. The contract is is what governs here. So it tries to contract out of common law. Here's the thing. In most cases, probably 75, 80% of cases, when an employment agreement tries to limit your termination entitlements, it doesn't do so properly, which means it doesn't limit you and you still have full termination entitlements under common law. So I would need to see that agreement. There's a 75, 80% chance that even though they tried to limit your entitlements, they haven't done so properly. It doesn't say what it needs to say in order to limit your entitlements, but I have to see that agreement. But this is very important. It's a very important point. This is a very bad clause to sign in an agreement because it could literally cost you tens of thousands of dollars that you would otherwise be owed. So it could be the difference between getting 10 months severance and getting 3 weeks severance. That could be the difference there. So Alpha Gaming, for me to tell you whether or not you're in a difficult situation because you signed that agreement, I got to see it. So you can connect with me through employmentlawyer.ca. Send me a copy of that agreement, and I'll tell you if you're one of the 80% where it doesn't properly limit your entitlements, or if you're one of the 20% where unfortunately it does. But very important, if you're accepting a job, okay, or if you're working and your employer wants you to sign a new employment agreement, one of the most important terms that you can look for is the termination terms. And we call this a termination clause. Is there anything in that agreement that tries to limit your entitlements? That could be more important, much more important than whether your salary is $75,000 or $80,000, because you may be fighting for that extra $5,000 in salary, but you're giving up $50,000 in severance. So think about that. Always have me look at your employment agreement before you sign it so that you can understand what you're signing, and also I can help you negotiate it if needed. So very important. Please do that and be smart. Don't give up your rights. All right. So that was Alpha Gaming. Thank you for that question. Again, I'm Lior Samfiru, the employment lawyer, if you're just joining us. And next question is right now from Manataran. I've been asked to relocate to a different province for my job. If I refuse, can I be fired? If I agree, do they have to cover expenses? They want me to take a contract if I move to the new position. Is this normal? Should I be concerned? So let's start with the easy stuff. If you refuse, can they let you go? Yes. Why? Because an employer can let you go for any reason as long as severance is paid. So they can say, we're going to let you go because it's Wednesday and we feel like it. Kind of a dumb thing to do, of course, but they could as long as severance is paid. So what they can't do is say that because you refuse, we're going to let you go without severance. All right. So ultimately, yes, you'll have to keep that in mind. As long as severance is paid, they can do whatever they want in that sense. But severance, again, is going to be substantial. Now, if you are going to relocate, it's up to you and your employer to agree to terms. Don't sign anything without me seeing it first. Don't sign anything that limits your future entitlements or future employment status. So obviously, I can't talk hypothetically here, but if they ask you to sign something, just send it to me, okay? I'll review it and I'll tell you what it means and what it does. and whether you should be concerned about it. But without seeing it, obviously, I can't say. There's no legal requirement that they pay for your relocation, but you may say, hey, employer, if you don't pay for it, I'm not going to do it. And then your employer decides. But there's no law that says if you relocate, they have to pay. That's something that you can negotiate and talk to your employer. There's no legal obligation to accept, but always the general rule is you can be let go with severance if your employer chooses to do so. So, Manataran, if you have follow-up questions, I'm still here. Or to connect with me off air, very, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, I'm Lior Samfiru, the employment lawyer, answering questions live. Next question up is from T. I work at a construction company. It's been extremely toxic. It's a tricky situation because it's owned by my ex-in-laws and their family. They're always yelling at me and swearing, telling me to do things, then get upset at me when I do, not allow me sick days, etc. I never signed an employment contract when I joined. Now they've told me they're giving me 2 weeks notice. Okay, well, if they've given you 2 weeks notice, nothing that happened before really matters. That harassment is not really the issue here because you're not going to be working there anyway. It's a question of, is 2 weeks notice going to be enough? The answer is absolutely not. Because you didn't sign an employment agreement, that's a very good thing, okay? It means you're owed much, much more. So, T, I don't know how long you've worked there or the type of job that you're doing, but you're going to be owed months' pay. So if let's say you're owed 6 months' notice, but they're giving you 2 weeks, well, they have to make the difference up by payment. So the issue here at this point, it's not so much the harassment. You're not going to be working there in a couple of weeks anyway, right? So it's about ensuring you get proper severance. You need to connect with me as soon as possible, today ideally. To connect with me, again, employmentlawyer.ca, up there on the screen, employmentlawyer.ca. I'll help you make sure you get everything that you're owed. All right, next question today is from Tina. Is it not illegal to be harassed, yelled at, screamed at, even though I work for a construction company? I'm a health and safety manager, but I'm not unionized. It's 100% illegal. It could be a breach of several statutes. It's illegal. So if you're being harassed, bullied, etc., you have to tell, well, you don't have to. Ideally, you want to tell someone in writing at your employer, HR, the owner, here's what's happening. They're legally obligated to investigate this and to fix the problem. If they ignore it, if they don't do anything, again, violation of several statutes, that could be a constructive dismissal. It could be many other things, potentially even a human rights issue. So ideally, in writing, you want to give them the opportunity to fix the problem. So they don't say, oh, we didn't know about it. You never told us. Give them the opportunity to fix it. If they fix it, fantastic. If they don't fix it, that's when you call me. All right. And I will get you out of there. I'll get you compensation. Or if you want to, I will get them to deal with the harassment issue. So Tina, that's what you do. Of course, it's illegal. No one should ever suffer through a poisoned work environment. I'm sorry you're going through that, but that's why you contact me, employmentlawyer.ca. Again, employmentlawyer.ca. So T, I said you've worked there for 2.5 years. And you asked for your job description, but they refused. But again, if you are being let go in 2 weeks, we don't care about the job description at this point. But I can tell you, probably going to be owed closer to 4 to 5 months notice. They're giving you 2 weeks, which means they have to make up that difference by way of payment. It's a wrongful dismissal. That's what you're calling. That's where you have to call me. Again, employmentlawyer.ca. I'm Lior Samfiru, by the way, the employment lawyer, with the last few minutes, a bunch of questions to still get to. Let's do that right now. Next question is from Bridget. Our manager has told us that a number of contracts are going to be cut because of some losses due to the tariffs. If you were let go at the end of the contract, are you owed anything at all? So I would obviously have to see the contract, but generally the answer is yes, you would be owed severance. Now, if you sign one contract, just one that said you're going to be working until the end of the year. So let's say you sign a contract till December 31st, 2025, and December 31st comes and they're not renewing that contract, potentially you're not owed anything else. If there were multiple contracts, that's different. If the date is after December 31st, but they're letting you go December 31st, yes, you're owed something. So obviously that information, that context is important. Best thing to do is send me a copy of the contract or call me and let's have a discussion so that I can understand more about your situation. So yeah, that's what you do. Employmentlawyer.ca to connect with me. Again, employmentlawyer.ca. Tina says, can you possibly give a free consultation? So about 75% of our consultations are free. In some situations, we do paid consultations. We can advise what the options are when you reach out to us. We try to provide as many free consultations, certainly for people that have been let go. We try to do that. But man, you know what they say, you get what you pay for. I'm very proud to say we're the top employment law firm in this country, and just our name on the letterhead resolves matters. So that's kind of how that works. But I'm happy to connect with you, happy to help. Let's see here. Bridget has a follow-up. I've been working as a contracted worker for the last 5 years, pretty standard employment otherwise. Yeah, you are absolutely owed severance. You're probably going to be owed 6, 8, even 10 months of severance, depending on your job and your age, etc. So you're not a contract worker. You're considered an employee. And that's a very good point there. A lot of people are misclassified as independent contractors. The company they work for tell them, no, you're not really an employee. You're a contracted person. You're an independent contractor. But you're going to work regularly for us. You're going to have regular hours, etc. Well, guess what? It doesn't work that way. If you look like an employee and act like an employee, yeah, you're an employee. And the fact that they call you something else doesn't change that. All it means is you've been misclassified. Nishat says, I got an appointment for September the 4th. In the meantime, should I quit my job? It's a constructive dismissal. Absolutely not. You do not quit your job before you talk to us, okay? Absolutely not. Never, ever do that. So speak to us. If it's an urgent matter, call us back. We'll maybe be able to get you in even before September 4th. You do not quit without talking to us. Okay, let's see. Maybe this could be the last question today from Squad Busters. Can you rescind a signed job offer after background check has been clear? So I'm assuming you mean that the background check came out fine, but you want to rescind the offer. Well, the problem is this: if that employee quit a job to accept your offer, so they were working, you made them an offer, they quit that job, now you want to rescind it, well, that's a problem because that employee relied on your offer, right? And now they lost something, so you may have to compensate them for their losses. It's very different if the employee was unemployed anyway, you offered them a job, now you rescinded, they haven't lost anything, potentially you could do that. So it's a question of, did the employee lose something in relying on that offer that you made them, okay? If they did, that's a problem rescinding that offer. So hopefully that makes sense. Squad Busters, if you need some more help, if you need to speak about this privately and individually, very easy to do. Just reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. Guys, wow, fantastic questions. You guys really kept me busy here today. That's amazing. That's what I want. I think I've got through all the questions. So just because the session is over now doesn't mean that I'm going anywhere or that my team is going anywhere. You can still reach out to me and my team. Very, very easy to do. Employmentlawyer.ca is the only thing you need to know, the only thing you need to do. Again, employmentlawyer.ca. Don't wait. Sometimes if you wait too long, you give up rights that you didn't even realize that you had. Don't let that happen to you, okay? I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Thank you so much for joining me today. I'll be back here. My other colleagues will be back here as well. But in the meantime, employmentlawyer.ca. Thank you, everyone. Have a great rest of your day, and we'll talk again soon. Bye now.